Good evening, everyone. I'm Shreya, student co-convener of Center for Legal Aid Program, NUSRL Ranchi. I'll be your host for this evening. On behalf of CLAP and ProBono India, I welcome the resource person, Dr. Manoj Sharma, members of the organizing committee, Dr. Kalpesh Kumar L. Gupta, founder of ProBono India, Dr. Kaushik Bakchi and Dr. Shweta Mohan, faculty conveners CLAP, student coordinators, and all the participants to the short-term course on legal aid and allied laws. For this session, we have with us Dr. Manoj Sharma. Dr. Manoj Sharma is an associate professor of law at Rajiv Gandhi National University of Law, Patiala. Before joining as associate professor at RJNUL, he has served as associate professor of law at Maharashtra National Law University, Nagpur. He has he has served RJNUL Punjab from 2012 to 2021 as assistant professor of law. Before joining RJNUL, he worked as a lecturer in law in Department of Law, Guru Nanak Dev University Regional Campus, Jalandhar, and Soldier Institute of Law. He pursued his graduation in Commerce, LLB, and LLM from Guru Nanak Dev University. He was awarded Certificate of Merit for securing second position in Guru Nanak Dev University in LLB. He has undertaken his PhD on the topic Center State Financial Relations and Analytical Study. We welcome you, sir. Over to you.
Thank you so much, Shreya, for your nice introduction. So, Dr. Kalpesh, thank you so much for inviting me to be part of this discourse, which is a wonderful initiative of yours and the Pro Bono. I hope I'm audible. Thank you. So, I have been asked to dwell upon crime and victims. As we understand, there's a great connection. I shouldn't be using the word great. I was going through a study. It says that the impact of crime on victims and their families can be multifaceted. That impact can last for a day. That impact can be lifelong impact. So when I got to study this Canadian Center of Justice Statistics, which made a study way back in 2007 that so far as violent crimes are concerned, these violent crimes, they affect the victims. As I said, effect may be lasting for one day. The study suggested that for 31% of the victims, the violent crime disrupted their life only for a day, but then there were victims, 18% of those victims, who could not attend to their routine work, who could not attend to their routine duties for more than 2 weeks. And so far as the emotional impact was concerned, 78% of the victims of the study, they said that they had a great emotional stress and impact of the crime. And therefore, the crime caused frustrations, irritation, confusion, fear of safety among a large number of victims. And the study also disclosed that so far as female victims were concerned, they felt unsafe while walking in dark because they were the victims of violent crimes. So they were afraid of going out once the in dark they felt lesser safe, and therefore that impact was long lasting, everlasting. And therefore that is where I at the outset said that okay, well, I'll do that. Give me a second. Yes, I think now it is in full screen mode. So that's what the opening statement which I wanted to make, that there's a strong relationship between crime and criminality. Of course, as the topic says, I have to discuss the theoretical aspects. I will not be discussing in detail the definition of crime, but I will definitely be discussing something about the victims. So the point which I wanted to make was that crime and victims, there is a correlation, there is a strong connection. So far as the crime is concerned, I'm not going to discuss these definitions, just some opening remarks, and then I'll go to understanding who the victims are, the definitions of victim, and of course the typology of victims. That is the theoretical concepts as they understand from the topic. So if we go back historically, we find that Manusmriti recognized some of the crimes. So if you see that these crimes were like assault, theft, robbery, murders, criminal breach of trust, cheating, adultery, rape, and as we understand that at that point of time, the number of crimes and therefore the recognized crimes and the recognized victims, they were very narrow in sense. With the passage of time, of course, we started, new crimes developed or new crimes were recognized, so to say. And therefore, if you recognize new crimes, there will of course be the victims of those crimes. As we understand that Western philosophy, we see Aristotle said man is a social animal, and therefore there is an interaction between man and society as a whole. And therefore, when we see there the crime and victims, in criminal law, when we say the victim of the crime is the society, and that is why in the modern criminal law, the prosecutions are carried out by the state, because we perceive that a criminal act is an act against the society. So if we see the Aristotelian perspective, where he said the man is a social animal, there is a continual conflict between that individual and society. Individual aiming for his own gains by whatever means, and society wanting an orderly society, and therefore there is a continual conflict between these two, and that's where law comes in. Durkheim, a sociologist, he was of the view that society without crime is not possible. And wherever there is a society, you will always find crime. We understand even in Ramrajya, there were crimes. Even in the ideal world, there are crimes. So crime and society can't be without crimes. So what is a crime? I'm not going into those definitions. Of course, we understand that it is an act which is forbidden by law, which is recognized by the law of that nation as a crime. It's an act or maybe an omission which is done deliberately with an intention, which has harmed the society or the individual, as the case may be, done with that intention, which is, as I said, recognized by law as a crime. As I said, I'm not going into that definition, but I'll of course refer to the geography of crime. That is an important aspect when we talk about crime and victim. One of my friends who was conducting a study on geography of crime, we understand that there can be various crimes or various places, crime hotspots, which are infamous for certain types of crime. I don't want to label any particular place or any particular community, any particular section or group. But then when we see the geography of crime, there's a pattern. Sometimes there is a particular hotspot where the crime is committed, which is more vulnerable to crime because of various factors, which may be social, which may be geopolitical, which may be others. So when we talk about crime and the victims, of course, in an area where, if we talk about the geography of crime, if there's a crime hotspot, then there's a larger section of vulnerable groups, and that is where even the victims would be much larger, not only the direct victims, but especially the secondary victims, which will be much larger in number, because due to that crime hotspot, due to that increasing incidence of crime, due to that crime pattern, larger number of public people would be terrified, and therefore they would be indirect victims of or secondary victims of that crime. So who is a victim? That's a question which has perplexed victimologists for long. Before I deal with this, I would like to, refer to 2, 3 works. It is claimed that there was a golden age for victims, there is a dark age, and there is re-emergence of the victim. So in victimology, it is claimed that there are 3 different ages. The old age, the ancient period, which was regarded as the golden age, which is regarded or claimed as the golden age of victimology, and where the criminal justice system, some of the philosophers are referring to that system as a victim justice system. So they said that in ancient times it was a victim justice system. It was a golden age when there was unwritten law, and therefore whenever a crime is committed against an individual, a member of the society, he, for example, in tribal societies, even some of the tribal societies even today, so what would happen is that the victim would demand a particular type of justice. He would demand maybe the revenge. He would demand maybe the blood feud marriages. He would probably demand the the compensation. And therefore, they say that age was a golden age so far as the victimology was concerned, because at that age, the victim had a direct active role in the justice system, and therefore the revenge system, that eye for an eye, or maybe if you have killed me or my family or any member in my family, you will have to compensate this much. So there the victim played a very, very important direct role in a criminal justice system. But then the system had its own drawbacks. Here the victim was perceived the one against whom, that primary victim against whom the crime has been committed. He would come, as I said, call the panchayat or the head of the sect, and then they would decide upon whatever kind of punishment or whatever kind of recompense to be given, or revenge or retribution to be given. For example, blood feud marriages even today in Afghanistan is one of the some of the sects in Afghanistan is still prevalent, where the victim is playing a very, very prominent role in the criminal justice system. But as I said, this system had its own drawbacks. I was reading some literature on blood feud marriages in Afghanistan, where when there's a long-standing enmity between 2 tribes or two individuals, a girl is given that it will bring peace. Girl is given in the form of that you will marry that boy and then it will bring peace. So blood feud marriages. Now the question is, who is the victim here? That's what I started with. That who is the victim? It has perplexed us, the philosophers, the jurists, the academicians, for long. So here, whether the victim is the person against whom the crime is committed, or in blood feud marriages, if the girl is given just because that some the other family has killed some member in my family, so I'm giving girl as in a marriage to them, to that family, which will remain there and perhaps face the suffering for the rest of her life. So the golden age, which is referred to by Javan and Moriarty as the age where the victim played a participative role, of course, it has its own disadvantages, and of course, it had to wither away. And then it is claimed by some of the victimologists that the dark age came. The dark age, which they are referring to, is when the law was enacted, when the written law was enacted, where we said that crime is an act not against an individual, but it is an offense against the society as a whole. Now, what happened with this phase was that, for example, if we see India also 1860 IPC, and if we see that 1898 the Code of Criminal Procedure, and 1872 the Indian Evidence Act, so victim had no role to play. Or if it would have been an exaggeration to say no role to play, but he had hardly much role to play. He would only set the criminal law into motion, would be a witness, but he would have no role to play in prosecutions, in filing appeals, in opposing bails. He would only be a mute spectator once he has set the criminal law into motion by getting an FIR registered. Then his job would only be to appear as a witness whenever he is called to appear before the investigation agency. That's it. So he was not allowed to engage a counsel. He was not allowed to file an appeal. He was not allowed to plead on the quantum of punishment. The once he has set the criminal law into motion, the entire prosecution investigation would be taken by the state because the crime was perceived as an act, as a crime against the society, and that is why the victimologists call this era as a dark age for victims, because a victim, the primary sufferer of the offense, of the crime, had no role or hardly much role to play in the criminal justice system. And then the victimologists call the third age, that is the re-emergence of the victim. Especially when we talk about 1950s, 60s, second half of the 20th century, where we find that in the West also that victimology as a discipline started gaining prominence, and we find some of the fine victimologists, their works are published, and now the victim gets some role in the criminal justice to play. So if we see historically, as I said, victim, the term victim is probably taken from the Latin word victima, which was used to describe individuals or animals who was to be offered as sacrificial goats, or who were to be offered as sacrifices to before a deity. So victim word has emerged therefrom, and therefore if you see that ancient perspective, the term victim was very narrowly interpreted. But as I said, historically, the since those ages, who is termed as the victim of crime, that is one thing which we have been finding very difficult to define. So who is the victim? Especially if you see that 1985 UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. If you see this 1985 declaration of the UN, that attempts to define who is a victim. So it's a very broad sort of definition. This definition you can see on your screens. It says persons who individually or collectively who have suffered harm, including physical harm, mental injury, emotional suffering, economic loss, or substantial impairment of fundamental rights through acts or omissions which are in violation of criminal laws. Now, this is very important. We say through acts or omissions which are in violation of criminal laws operative within the member states, including those laws which are prescribing criminal abuse of power. Now you see, if you see, though this definition appears to be broad-based, and it includes all those persons who are individually or collectively, that means the society as a whole, the community as a whole, or individual, the primary victim, those who have suffered harm, whether that harm is physical, that harm is psychological, that harm is emotional or economic, as the case may be, or those whose rights have been affected due to the act or negligence which has been declared to be a crime by the criminal law in force in that state, all those would fall within the definition of victim. But then this definition even would not include, would not be, I mean, very sufficient, exhaustive definition, because it would also, if I refer to the case of children going behind bars, that is whom we call, or whom I have referred to in my previous discourses also, as the invisible victims of crime. Now, these children who are less than 6 years of age and who are in jail not because they have committed some crime, but because their mothers have been accused of committing some crime in the past. So these children, if I refer to the NCRB data, so NCRB 2021 report, which says as of 31st December 2020, it says that there were 1,400 odd women with 1,600 odd children who were in jail. Now these victims, I call them as victims because these children who are either born in jail or they are, sent to jail along with their mothers because they are under 6 years of age, and there is no one outside who can take care of those children. Now, these children, I am referring to them as invisible victims of crime because these persons are forced to live, these children are forced to live in jail-like conditions, where, and in most of the cases, their mothers are under trials. They are not even, they are not even, I mean, uh, convicted. They are only under trial. Most of them are under trials. And see the kind of victimization they will have. Some of them are born in jails, and there are females who have got two children in jail, as is evident from the data that 1400 odd women with 1600 odd children. So therefore, there are women who have got more than one children, both are in jail. And they are in jail, they are living in unhygienic sort of conditions. They are living in overcrowded places. They are living with some of the hardened criminals. And therefore, they have not seen the outside world for the first 6 years of their life, probably. Or maybe whatever time they've spent in jails, what kind of upbringing they will have. But then if you see the UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, even the case of invisible victims of crime or the children going behind bars, that would not be covered in the definition of victim. So are they not victims? They have not committed any crime. They are victims of what? Are they victims of abuse of power? Are they victims of the system? Or what? That is what I said, that the definition of victims, which is given in the UN Declaration of 1985, that definition may also be not very exhaustive one. Finally, if we see the Code of Criminal Procedure of 1973, it was amended by the Amendment Act of 2009, which finally introduced the definition of victim in Indian criminal justice system. That is, Section 2WA was inserted by the Amendment Act. Now, if you see this 2009 amendment that says victim means a person who has suffered any loss or injury caused by reason of the act or omission of which the accused person has been charged. And the expression victim includes his or her guardian or legal heir. So now see this definition again. It means a person who has suffered any loss or injury, and that loss or injury is caused by reason of the act or omission of which the accused person has been charged. So here, the children of those women, she's an accused here. She's an accused here, and she has been charged with certain offense against a victim, but her own children are also the victims. So see how the victim itself, the definition of victim itself can be very, very perplexing. So when we see the, sorry, give me a second. Yes, when we see the definition of victim, we find that victims may be primary victims or direct victims. So one who has suffered that injury, one who has suffered the harm, one who has suffered the emotional or physical harm, they are the direct witness, direct victims or the primary victims. Of course, we are saying now that the immediate members of the family, they should also be included in the category of primary victims. Then there may be indirect victims. Indirect victims are those members who have close contact with the primary victim, sorry. Witnesses are also categorized as victims by many victimologists. We understand witnesses can also be the victims of the criminal justice system, and they are also the victims of the psychological harm which has been caused to them. They might have witnessed a very grave, violent crime, and that violent crime might have caused so much of emotional shock and trauma to them that even the witnesses who might not be related to the victim, who might not be related to the family of the victim, they might also suffer some emotional harm, some economic harm, because they have been witnessing that crime or they have witnessed that crime. And then, of course, the secondary victims, sorry, that is the tertiary victims, which can be the community, society as a whole, the state as a whole. So victims, if we see the typology of victim, so they can be, as I said, direct victims, they can be the indirect victims, they can be the witnesses, or of course they can be the tertiary victims. Benjamin Mendelssohn, he gives this six types of victims. Now, this Benjamin Mendelssohn, who was a French Israeli lawyer, who started, studying this victims in 1947 with respect to rape, when he was dealing with the rape case. So he tried to find out the relationship between the crime, criminal, and the victim. And on the basis of what he studied, Benjamin gave six categories of victims, six types of victims. Sorry. He said there are certain witnesses who are totally innocent victims. These innocent victims, they have not contributed anything. They have not provocated the crime. They are not contributing in the commission of the crime. They may be there by chance. They have not uttered even a single word, but then they have suffered. So victims may be those who have got no provocative, no contributive behavior towards the attack. They are just passerby. Some terrorist came and he started, firing. And some passerbys, they get affected, and maybe all of them, they are killed or they are hurt. Now these are completely innocent victims. And there may be victims who are very guilty type of victims, who have contributed in the commission of crime. Sometimes what happens is that a fight ensued between A and B. Now, initially, the A is the aggressor. He started the fight. He was the aggressor. But then these friends came and they gave a serious thrashing to A, and therefore A, who started that fight, now he has lost maybe one of his limbs. So he is a contributory victim. He is a victim as well as he is the accused, because he started the fight. Probably he was the initial aggressor. He his I mean that fight has ensued because of his actions, but maybe due to circumstances which went beyond his control. Now he is a victim, but then he has participated. He is not a completely innocent victim. So he his behavior has contributed to that attack or to that harm which is done to him. So victims may be, another type which he gives is voluntary victims. Now again, this definition or this typology is not free from criticism. So you see, Benjamin Mendelssohn's typology says there can be voluntary victims, and he is referring to the cases of suicides. He's referring to the cases of prostitution. Now, again, this typology, as I said, is not free from criticism. When we talk about prostitution, he would say that a girl who is landing into prostitution, she is a voluntary victim. But then we understand the circumstances, she might have been trafficked into prostitution. She might have been forced into prostitution by other circumstances. So she may not be a voluntary victim, but then, as I said, Benjamin Mendelssohn has prescribed this kind of typology, that there may be voluntary victims, even in the case of suicides. As we understand, suicide may be compelled. Suicides may be the reason of many other circumstances, and therefore the person may have been compelled to commit that kind of an act, and it may not be cannot be termed as voluntary victim. Sometimes the victims persons become victims because of their ignorance. As I said, sometimes they exhibit some sort of trait for which they become vulnerable. Sometimes you unwillingly you do something which makes you vulnerable, especially when we talk about cyber crimes. Sometimes you click something, and that comes that due to your ignorance, and therefore you become vulnerable due to your own ignorance. Sometimes the victims, we understand, provoking someone is not an example of voluntary victims. It is basically when we say he is a participative sort of victim, he is the one who is also guilty of that particular act. Because, as I said, some victims are more guilty than the offender. Some are mostly guilty victims. Some voluntary victims are, he is categorizing like suicides or maybe drug abuse, because you are abusing the drug, you are consuming the drug yourself, nobody is compelling you to, or maybe you are engaging in a sexual act for consideration. So he's saying these are the voluntary victims, but he's not referring to when one is the aggressor or one has contributed. He says these are the persons who are guilty along with the offender because they have provoked a criminal act. So, for example, if you see the fourth typology, yes, I'll refer to that victimless crime also. Uh, if you see the fourth typology where they have said that sometimes victim provokes a criminal act. For example, he has first initiated, given the first punch, but then he ends up the loser. So that is where he's saying when the victim has also participated, contributed in just 1 second, let me see. Mr. Satyam, intentional knowing the nature of the crime. Yes, that can also be included. Uh, so let me first wind up this typology of victim. You take all the questions. I understand that I still have 20-25 minutes before I take the questions. So then there can be victims who are pretending to be victims. Sometimes we also understand that people lodge false FIRs. They lodge false cases. So they pretend to be victims. They are imaginary victims, or they simulate that they are also victims, though they may not be victims in real sense. If you see the 1968 work of Stephen Scaffer, that is The Victim and His Criminal, a study in functional responsibility. Now, Stephen Scaffer is giving you 7 types of victims, where he's talking about unrelated victims. As he said, maybe somebody who was present there by chance, who has not contributed anything, who is not engaged, involved. There is a enmity between two families. The third person is passing there by. He just came, and in that fight, he sustained some injury. He is not even trying to stop them. He is only passing by, and he has sustained an injury. Provocative victims, as you have referred to, some of you have referred to. Precipitative victims, yes, biological weak victims and socially weak victims, these two are very, very important categories. So, for example, the children who are victims of crime. So children above below 16 years or below 18 years, they are also prone to many crimes, and therefore these are those victims which are biologically in a weak situation. And we understand that many countries have enacted various laws to protect these biologically weak victims. Some people also include women in that category, though I may not agree with that. Socially weak victims, of course, there are certain communities, certain sects, certain groups which are socially very weak because they are in disadvantaged position, vulnerable sections of the society, as we call them, especially elderly people, especially people belonging to lower strata, especially people who have, no roots in the society. So these are socially weak victims, and therefore these are vulnerable victims. Due to their social standing, due to their economic standing, they are vulnerable persons. Due to their, maybe, as I said, senior citizens, they are vulnerable victims, and therefore they are more amenable to a crime being committed against them. Same is the case of biologically weak victims. Then there may be self-victimizing and political victims. I'll not deal with that to an extent. We understand who can be. Then, if you want to include in that political victims, there are victims of the abuse of power. Victims of the abuse of power maybe they are political victims, or they are the victims of the system. I would refer to two important instances in this. Udal Shah versus State of Bihar, 1982, is a classic example. Who is a victim of the abuse of power? Now, this Udal Shah, who was actually, was arrested and sent to judicial custody. Now he was I mean discharged way back in 1968. But the letter which reached the jailer, he kept it in his drawer. He got transferred, and the time passed by. 14 years down the line, he remained in jail. And 14 years thereafter, some public spirited person got to know that why are you in jail for such a petty crime? And then it comes to limelight that this person has been released way back in 1968, 14 years ago. So he was the victim of the abuse of power. You may call him political victim. You may call him victims of the abuse of power, or the victims of abuse of the system. So now he remained in jail for 14 years for no fault. He has been discharged by the court 14 years ago. So again, this kind of victim can be there. Machang Lalong is another classic example. So Machang, who was from the northeast, from this Assam, who was arrested in 1951 for the offense of causing hurt. Now he's arrested in 1951. He remained in incarceration for 54 long years without there being any trial. So he was initially suspected to be having some psychic issues. He was sent to psychiatry. Once he came back, 40 long years thereafter, he remained in jail without the trial having commenced. So he remained in jail till 2005 when some NGO visited and got to know what kind of crime you have committed. So he was booked for a crime of causing hurt, for which he would have been released long back had this been proved. So he remained in incarceration for 54 long years when he was released by the court. Of course, this again is a classic case of victim of the abuse of power. So in 2005, when he was released, there was no one in that village who knew him. So whatever family he had was in the form of the jailmates. So he was released in 2005 when he had already past the prime of his life. He was very elderly person at that age and he survived only 2 years. In 2007, he died. Though the Supreme Court ordered payment of compensation to him also, but again, that can be termed as victim of the abuse of power. So that's what I said, that this Udal Shah and Machang Lalong, these are two classic cases where we find that these are the victims of the abuse of power, or political victims can also, you can call them. So far as other vulnerable victims are concerned, we understand that children, minorities, elderly persons, or maybe due to socioeconomic conditions, the poor people, people living in slums, SCs, STs, and many other communities, they may be vulnerable victims for every type of crime being committed against them, not because that they have done something wrong, but because of their socio-economic, biological, or other reasons. So therefore, when we talk about victim, as I said, there's a very wide the sketch. It's a very wide term, and that is why we have found it very, very difficult to define who can be a victim. And that is where the theoretical understanding of victim, we are still at the nascent stage. That is probably the reason that we attempted to define it only in 2009, and we have not defined it earlier. So far as this victim is concerned, as I said, though it's difficult to define, but what role he has to play in the criminal justice system. As I said, in the present criminal justice system, victim, of course, he is having all the fundamental rights granted by the Constitution of India. But so far as the crime perpetrated against him is concerned, as I said, victims can be, primary victim, he can be secondary victim, victim can be a continual victim. There may be certain offenses which are not offenses, one-time offenses, which are continual offenses. For example, sexual harassment at workplace. It may be one time or it may be a continual offense. For example, domestic violence. It may be one time or it may be a continual one. So the victims may be victims of one single crime, or victims may be victims of multiple crimes, continual crimes being committed against them continually over a period of time. So these victims, as I said, though they have all the fundamental rights granted to them on paper by the Constitution of India, yet when we talk about the criminal justice system, till 2009 or till 2005, if I go back, they hardly had much role to play in the criminal justice system, apart from moving the criminal justice system by filing an FIR. And that too, we understand that in many cases, FIRs were not registered. and they would be made to run from one place to another till the judiciary came to the rescue by evolving the concept of zero FIR, that of course you can lodge an FIR at any one place, and of course that police station will transfer that FIR to the jurisdictional police station. That is why we call it zero FIR. So apart from setting the ball into motion of the criminal justice system, as I said, that the victim did not had much role to play before 2005 in particular. So he would only, as he said, lodge the FIR, participate in the investigation, that participation in the sense that he would visit the police station, and whenever he is required to appear by the police, he would go there, he would be examined, he would be examined as a witness by the IO. But then we understand here that the treatment of victims before this 1985 UN declaration by the police, even thereafter, has not been very encouraging, has not been very motivating. These victims are further victimized by the criminal justice system in more than one ways. One is initial actors in the criminal justice system is the police. Subsequent actors are the prosecution and courts. So the initial actor, that is the police, we understand that many victims belonging to the lower strata, they find it difficult, they find it terrifying to visit a police station even if some offense is committed against them, because they believe that they will be more victimized there. So the first point of contact for the victims, that is even lodging an FIR, becomes a horrifying incident in many cases. I'm not saying in all the cases. Position has improved much, but yet much is desired to be done. Till Lalita Am I audible?
Yes, sir, you're audible now.
Thank you so much. So as I said that the Supreme Court of India, yes, yes. Thank you. Thank you. In Lalita Kumari versus Union of India, the Constitution Bench has to declare that the person in charge of police station has no discretion. He's bound to lodge an FIR, to record an FIR when an informant approaches them that a cognizable offense has been committed. So that means that itself is testament to the fact that it was very difficult even for literate person to visit a police station and get an FIR, just leading to further victimization of the primary victim as such. So therefore the first actor, as I said, the police, their role in dealing with the victims, that even before 1985 or even after 1985 has not been at par with the UN norms. You see the UN United Nations Office on Drugs that has also prescribed the standard operating procedure to be followed, yet that was not followed. And then apart from this role which the victim was expected to play, setting the criminal justice machinery into motion, he did not have any further role to play. But now, as we understand, if you see section 301 and 302 of the Code of Criminal Procedure, now the victim can also engage a counsel, private counsel, though that private counsel do not have the power to conduct the prosecution. Prosecution, as I said, is conducted on behalf of the state, because crime is treated as offense against the state and not against the primary sufferer only. So therefore, that primary sufferer cannot engage a counsel to to prosecute on his behalf, the counsel engaged by that primary sufferer, that is a victim, will assist the public prosecutor in conducting in the conduct of the prosecution. The oral submissions are basically made by the public prosecutor, and the private counsel engaged by the victim, he will assist the PP in conducting the prosecution. Of course, they can submit the written submissions for sure. Apart from that, as I said, the victim can be an important witness. So two roles which he played was one, lodging an FIR, second, being a witness in court. But then, as I said, at both these stages, whether lodging an FIR, participating in investigation, or whether that is appearing as a witness, in all these cases, he was further victimized. Victimized that, for example, when he is appearing as a witness in court, he was required to appear many times. Sometimes the opposite party counsel is not there. Sometimes the court is closed. Sometimes the lawyers are on strike. Sometimes the advocate is busy in some other court. So these victim witnesses, they would suffer many hardships in giving their testimony in court. And then the ordeal of cross-examination itself was something which witnesses are scared of, especially victims are scared of. And when we talk about the victim of sexual offenses, the ordeal becomes much more difficult. For them, they have to go through that ordeal once again. Of course, the amendments in the form of 164A in the Code of Criminal Procedure has actually helped. But before, as I'm putting it again and again, before 2005 to 2018, this is the period when we find that the criminal justice system in India is recognizing victim as an actor in criminal justice system. Prior to that, victim was not much recognized in the criminal justice system. Whether we see 357A, the compensation schemes, the victim compensation schemes, whether we talk about the compensation under 357A, whether we talk about 372, the filing of appeals, whether it is engaging counsel, all these things, or the definition of even the definition of victim, all these things have emerged only after 2005 amendments till 2018. So as I said, the ordeal of the victims of sexual offenses, that was much more difficult because they had to go that thing again and again in the court. The opposite counsel would ask them many questions. For example, you can refer to Mathura case, the kind of the kind of judgment given in Mathura case, where the or the two-finger test type things, the kind of ordeal which the victims had to go through. Even if, we also have to be mindful of the fact that in August 2023, the Chief Justice of India, Dr. D.Y. Chandrachud, issued a booklet as to the language to be used in sexual offences cases. Why we had to use that language? Because there were gender stereotypes. There were gender stereotypes in the language being employed in the court, and therefore the victim of such offenses was further victimized by the use of that language, by those stereotypes which were prevalent in courts. That's what I'm putting it again and again, that the victims who are the victims of the initial crime, they were further victimized by the system. I would not label accusations against a particular participants, the stakeholder, but I would say system as a whole. But then it is only that now when we see the role of victim, the things have changed. As I said, 164A has been included. 164(5)A, we find another provision for the victims of rape. We find provisions for compensation, or the role which the judiciary has played, whether it's interim compensation to victims, or most importantly, I would say 372, the amendment of 372, when now we have given that right to the victim to file an appeal. So now the victim has also the right to file an appeal, which hitherto he was not having. And if you see, the scope of the right of the victim to file an appeal is a little wider then the scope of filing of appeal by the state. So victim can also, under the proviso to 372, now file an appeal against the order of acquittal. He can file an appeal. So earlier, even victim did not even have the right to file an appeal. The appeal would be filed by the state, the prosecution. The primary sufferer did not even have the right to file an appeal. So the criminal justice system, as I said, the primary victim was ignored for long. He was only appearing in court, seeing for his own concern what is going on in court. If he is called as a witness, he would appear as a witness. Then again, he will have to come to the court multiple times. So you can understand the kind of the time which is taken. Speedy trial, which though has been recognized by the Supreme Court of India as a fundamental right implicit in Article 21 of the Constitution, yet in practice we understand even the criminal trials are taking a lot of time, and therefore the victim witnesses would have to travel to the court n number of times. Initially, as I said, the primary focus of the Constitution of India was also on the accused. And that is where you will find, whether it's Article 20 or it's Article 21, the primary focus of the Constitution was not on the victim, but it was on no person accused of an offense, Article 20. So therefore, whether we talk about Article 20 or 21, what we call as most fundamental of the fundamental rights, the focus was not the victim. Focus was the accused, because at that time it was perceived that accused himself can be a victim, and accused, when he is pitted against the state, he is required to be protected. He is required to be given certain fundamental rights. Victim was somehow lost in the entire gamut of rights. So it is of late, as he said, especially in the second half of the 20th century and in the last decade of the 20th century, that we find that the victim's role has increased in the criminal justice system. He has got right to challenge the grant of bail. He's opposing bail applications in court. So therefore, now the victim is playing more role. Of course, he can also claim compensation, as I referred to, under 357, and of course, interim compensation under 357A. So that is a little bit about the theoretical. I'm not going to discuss the rights of victims, because I believe that there is another session on rights of victim by Dr. Abhinandan Basi. And there was a session on the human rights of victims yesterday also. So I'll not be discussing the rights of victim. I would rather love to have some sort of interaction on the theoretical understanding of the concept of victim.
So much, sir, for an informative session. We can have a question answer session. Participants are requested to please put their questions in the chat box itself, or you can raise your hands. We'll unmute you. What skills are necessary to work effectively with victims?
It's a very difficult question, so to say. See, the question is, from which perspective you are talking about. One, as I said, the primary actor, the first actor with which the victims comes across is the police. Now this, we keep on saying that they are being sensitized to human rights. They have been sensitized to deal the victims with compassion, with empathy. But then I will not be able to verify it or say it with certainty that all police officers are dealing with victims with compassion and with empathy. Rather, the account which we get from victims, that is very, demotivating, so to say. So probably what we say, empathy is the most important thing. We have to put ourselves in the shoes of the victim, see what kind of struggle he has to go through. So most important skill is that we have to make him understand, bring him to calm him down, to probably reassure him that he is not alone, to probably tell him that the entire system is with you. to tell him that this crime will not go unreported, to give that kind of reassurance, probably. And of course, the most important thing, rehabilitation of the victim is very, very important thing. Rehabilitation and restitution. Unless you have that, you cannot reassure the victim. You have to. He is the victim of crime who has suffered all kinds of loss, the emotional loss, the physical loss, or if the person is killed, his family, his children who have no bread earner now, the economic loss. So how do you rehabilitate them? That is very very important. So rehabilitative justice, that is one of the most important part when we talk about victimology. So apart from empathy, compassion, apart from reassurances being given, of course, there is a need for compensation, interim compensation, and rehabilitation. These are some of the things which we have to do. Yes, I can see the questions here. Let me read them and I'll answer them.
Sure.
The question is, do you find any legal loopholes in the system regarding the anti-trafficking prisoners, which stands as a barrier to improvement in their conditions? Yes, legal loopholes, if you want to say, or maybe the systemic loopholes, I would put that way. We understand the first thing is that the number of cases which are pending, that itself is a big issue. So when one magistrate is disposed of probably 40 cases in a day, you can't expect him to I mean decide all the cases, and therefore the pendency goes on increasing. You see the NCRB data, the number of cases filed every year and number of cases disposed of. So the pendency is increasing every year. You hardly find any year where the number of cases, number of FIRs filed, number of cases where challans have been presented, and the number of cases disposed of by the court are equal. Rather, every year the pendency is increasing. So the first thing which I feel is that probably we need to increase the manpower. We need to increase the number of courts. Probably that is one thing. So far as the legal loophole is concerned, I think when we are giving far too many remedies for every single act, that creates a multiplicity of litigations, and therefore that not only contributes to pendency, but it also leads to delay in the disposal of the cases. For example, if I have to talk about I'll call them victims, those who are under death sentence. Now they are under death sentence, they have been awarded death sentence, and you take 10-15 years for the final disposal of their case. Now they were accused, of course, they are convicts, of course, but now they are the victims of the system also. So probably giving everyone too many remedies. That is one point. That is one issue. Even when we talk about system, I'll refer to one example from the state of Punjab. Now we in 2022, the state of Punjab has constituted Punjab Bureau of Investigation. One of the few states who have done this. So what they have done in this PBI, Punjab Bureau of Investigation, they have engaged counselors. They have hired advocates. So they have recruited as such the advocates, young advocates. Now what these young advocates are doing, they are helping the investigation agency during the investigation itself. So whatever the evidences are being collected by the police, there with every police thana, one officer from the legal officer from the Punjab Bureau of Investigation will be attached. So whatever the investigation progress is there, whether the investigation is being conducted in time, what kind of evidences they are collecting, whether those evidences you will be able to sustain in court, how to maintain chain of custody, how to, seal the evidence, what kind of chain of custody is required to be maintained. All these legal entangles, now they have a ready reckoner sort of thing. They have a kind of. So now, this is one thing which we are lacking. Whatever the police is doing, of course, most of the police officers may be lacking empathy, compassion, because they are overburdened. They have far too many functions to perform. Law and order maintenance function is one, and investigation is another. Investigation, most of the time, that becomes a secondary aspect for them. So then they want to dispose of the case one way or the other. They want to file the challan one way or the other. So once they unless they have some kind of legal advice available at that point of time, and some sort of mechanism to monitor that, of course, whether they are whether they are completing the investigation in time, what is the progress of the investigation, of course the system cannot improve. Speedy trial is not only for the accused. Speedy trial is also meant for the victim. Victim can't be made to suffer to wait for 20 years for getting the final judgment of the case. Then that's what I'm saying. Then the victim is further victimized. So probably one thing which we can do is with regard to engaging the counsels as the state of Punjab has done, and at the investigation level attaching them. So far as that will of course have 2-3 advantages. One, it will probably lead to swift completion of investigations. And it might also lead to many cases where the police officer, when he's presenting the challan, he can present the challan or he can present the closure report, as the case may be. That there's no case to proceed with the investigation, with the trial rather. So that can help one thing. So it will also lead to the number of under trials prisoners being reduced, because once they are discharged, of course, the number of prisoners will come below. Secondly, our bail system is suffering from property-oriented bias. The concept of bail, unless we introduce 436A, why we were compelled to introduce 436A in the Code of Criminal Procedure? There were cases where the persons had suffered more than the maximum prescribed punishment. They were in jail. They were languishing in jails. There were many cases when the persons were languishing in jail for more than the maximum prescribed punishment for the offense they have committed. So that is where the judgments of the Supreme Court compelled the legislature to insert 436A. But then, having said that, we still are saying, I mean, we have said bail and not jail. But then we understand the bails are denied in many cases. The poor victims, the accused who have been framed, he may not have sufficient money to approach the higher judiciary and get the bail from there, and therefore they keep on languishing as under trial prisoners in jails. The Supreme Court had mandated that the Chief Judicial Magistrate shall visit the jails every month, and therefore, what is his job to do? He has to see how many under trial prisoners are there. But despite that, we have cases like Machang, who are languishing in jails for 54 years under trial without the trial having commenced. So probably there are many things which we need to many loopholes. The bails are denied, so maybe liberalization of the bail. Maybe, as I said, bail system is suffering from property-oriented bias. Cases where they may not have the means to furnish bail, maybe they can be released on their own bond. Maybe, as I said, the assignment of the counsel to the investigation branch, that can be another thing which can reduce the under trial prisoners from the prisons. That is what I have to say, Swami. Another question which says how sexually abused victims can be rehabilitated and made any children effectively. That is very, very, disturbing thing that, as he said, sexually abused victims. See, I was coming across some of the studies by Tata Institute of Social Sciences. Now the victims of offenses, and of course, even of the victims of women prisoners, children of the women prisoners, they were not willing to send the children to the institutions. What is the reason that we do not want those children, those who are victims of crime, or those who are the children of the women prisoners? Why we don't want them to go to institutions for rehabilitation, for affirmation probably, or for rehabilitation? Probably there is a trust deficit. Probably the institutions, I don't want to accuse them, but then probably the institutions are not treating them properly. So maybe that is what I said, what the UN rules are saying, compassion and empathy. These are the two things to deal with the victims of, all kind of victims, including sexually abused victims. But for rehabilitation, of course, the first thing is psychological, assistance which we have to give them. Because the sexual offense, of course, it has a very serious physical trauma, but it has a greater psychological trauma. So for rehabilitation, the first step would have to be the psychological assistance which we provide them, counseling at state cost with best counselors, which is what we are required to give them, because unless they are given that neuropsychological kind of assistance, you can never be able to rehabilitate them. And if they are children, of course, they have to be probably, I mean, if you see the victim compensation scheme in India, and if you compare that with the victim compensation scheme in the West, we do not have the provisions for relocation of the victims. Victim witnesses, we do not have the schemes for their relocation. I mean, even the witness compensation scheme of 2018, of course, we can provide them assistance, we can provide them security, but do we have the schemes to relocate and rehabilitate them, to give them, I mean, to change their identity and then to send them to some other place and then to rehabilitate them there, to give them schooling there, to give the employment there? We don't have that. Probably these are some other things which we have to, I mean, perceive to contemplate in future, and probably that is where we can start with psychological assistance at the beginning, and then of course, as I said, we have to go a long way to rehabilitate them by maybe in some cases where the witness on the advice of the counselor is having so much of psychological trauma, to rehabilitate him, giving a new identity, settling at some other place, giving them schooling, giving them their employment at other places, to settle them from the place where they've suffered this kind of offense. That is what I have to say, Miss Sangeeta. There is another question, if I can say. Yes,
Muskan is
please.
raised the hand. Muskan, sir.
Yes, yes, please.
Muskan, over to you.
There is some problem with switching off. I mean, uh, switching on with the mic. So, may I read out the question itself?
Yes, please. Yes, yes, yes,
Ah,
yes.
okay, so we have another question. That is, how does the legal system ensure fair treatment for victims in cases involving crime when mental illness contributes to recurring issues? When, yes.
Can you please repeat the question? Sorry, I lost sense.
Sure. How does the legal system ensure fair treatment for victims in cases involving crimes when mental illness contributes to recurring issues?
See, as I said, so far as the present system is concerned, apart from the judicially laid down rules, we do not have any provisions in the present law as such. That means the CRPC, IPC, Evidence Act, the core of the criminal law, for rehabilitation of the victim. Yes, there are judgments of the Supreme Court where the Supreme Court has ordered rehabilitation and also provision of, as he said, the psychosocial assistance. So, as such, apart from the judicially laid down guidelines, we do not have much on so far as the laws are concerned. Present laws are concerned. I'm not talking about Bharatiya Nyaya Sanhita and Bharatiya Nagrik Suraksha Sanhita. So, so far as the victims, as I said, are concerned, they even there are some NGOs. Even that I would not be saying that in all the districts. So the legal system, as such, is not offering much to the victim in terms of, the offense which they have suffered. And even when there are guidelines from the Supreme Court for provision of psychosocial support, yet those guidelines are hardly implemented in most parts. I'm saying in most parts, majority. They are, if you visit a police station, they will not be aware of those psychosocial support. They will not be aware of where to go, which NGO to probably refer to. What are the counselors available for such kind of an offense? And when we talk about the continual offenses again, even when we talk about Protection of Women from Domestic Violence Act, there are still states who have still not nominated officers under that 2005 Act. So therefore, the legal system as such do not, as I said at the beginning also, that the victim was a lost one in the criminal justice system. Yes, now that is why I said there are three ages, as I said by the victimologists, the dark age, the golden age, the dark age, and now there's a re-emergence of the victim. But even now, the victim has got a very limited role to play in the criminal justice system. And of course, as I said, he can engage a counsel. But then psychosocial support, yes, it is existing in the guidelines, but then in practice, this is hardly been implemented. Especially when we talk about I'm not talking about the metropolitans. I'm talking about the rest of the country.
We can take up the last question for the day. So, what are your views on the victim compensation scheme? Forgiveness of victim
As I said,
how can one?
yes, please. Please
Yes,
go
sir.
ahead.
Yes, sir. The procedure to avail the scheme.
See, if you see there is no victim compensation scheme as such. We have witness compensation schemes of 2018. So far as victim compensation under section 357 and 357A, when you see those, the application has to be moved. We have that National Legal Services Authorities. So if you see in each of these states, there are in each of the districts, there's a district legal services authority, there's a national legal services authority, there's a victim compensation fund. That victim compensation fund, out of that fund, you can file an application for grant of compensation at 357A, as well as interim compensation. But there are three things. One, when the matter reaches the court, that is the first issue. As we understand, once the police presents a charge sheet, then only the matter reaches the court. 172 of that criminal procedure, 173 of that criminal procedure rather. So once the matter reaches the court by way of a charge sheet, then the court is apprised of the offense being committed, who are the parties to it, and all that. Who is the accused, who is the victim. Of course, when an FIR is registered, matter is sent to the Ilaka magistrate, the jurisdictional magistrate, yet only the bail applications or other things are being heard of. So my point is, when the judicial intervention actually comes, that comes when the challan or charge sheet is presented, which is required to be presented within 60 or 90 days, depending upon the gravity of the offense, the nature of the offense. But then there are many cases where the challans are not presented even after 60 or 90 days. The only thing which the accused now has is that he has right to default bail. But then if the challan is not presented for 60 or 90 days, now the victim has filed an application in the court for grant of compensation out of the victim compensation fund. It is not that, interim compensation. Of course, the final compensation will take time for calculation and for giving. Interim compensation is the most important part, not the final compensation, because the compensation required at the initial stage. He has to contest the matter. He has to file the matter, contest the matter, and he needs expenses probably for medical treatment. For example, if you see 360B, 326B offenses, acid attack type cases, gang rape type cases, you need interim compensation more than the final compensation. So even interim compensation takes a lot of time in courts under 357A. So the procedure is prescribed under 357A of the Code of Criminal Procedure, where you can file an application. But then my point is that I'm not very satisfied with the working of that provision, because it takes a lot of time even for the grant of interim compensation. And for me, if the interim compensation is not given immediately, there's no question of rehabilitation later. Once he has gone through that ordeal for 6 odd months, 8 months, now he has learned to live on his part. So now if you give the belated compensation, that you are doing it for the sake of justice at your end, but that does not serve the purpose. That's what my take is. Yes.
Thank you so much, sir, for an amazing session and addressing all the queries. Now I welcome Dr. Kalpesh Kumar L. Gupta, founder of ProBono India, to deliver the vote of thanks.
Yeah, thank you very much. Yeah, thank you very much, Manoj sir, for talking about this very like I would say we keep teaching and then learning the IPC, CRPC, and we unfortunately don't discuss the victims and their rights and what are the issues and challenges while implementation different schemes. And you rightly stated, like, 3 stages earlier that they used to call as, like, mute spectator, right? They like didn't have a say in anything in the criminal justice system. Later on, a lot of things came introduced by the government, and then obviously the judiciary also intervened in some of the cases. I hope all the participants, we have some participants from student, faculty members, and professional also. You got some idea like what who are victims and different schemes. And then sir rightly pointed out, like, practical difficulties in implementing those kind of schemes. Again, like, we have to raise questions, and some of the, like, well, again, some states still they have not implemented this kind of scheme, and the poor in implementation of giving the compensation victims. So sir, I, on behalf of the organizing committee, sir, I am thankful to you for sparing valuable time, and then thankful to again, like, there for various our initiative that have taken in last few years. So look forward to seeing your future also. Thank you very much, sir.
Thank you so much. Thank you. Thank you. Thank you.
Thank you so much, sir. With this, we conclude this session until we meet again tomorrow. Thank you.